Welcome to Public Enemy Number 1, the police whistleblower. As you can tell, I'm coming to you here on episode 4 with a new mic and much better audio quality. So I apologize for the first 3 episodes. But if you're still with me, then thank you for your patience. As I always do, I will give you my typical trigger warning that if you have any moral trauma or institutional betrayal in policing, you may want to take care in either not listening to this episode or find a way to de-stress at the end. Now, I said at the end of episode 3 that I was going to take you into a deep dive of the HRTO proceedings, and that's because the part that I've told you so far is really just an overview of everything that's happened at the HRTO. I do want my listeners to truly understand all of the key factors contributing to the fact that this has been ongoing for 7 years. This is a careful balancing act for me because these matters are still before courts and tribunals. But the reason I chose to put this podcast series together is because so much has happened to date that I truly feel needs to be known by the very people that are paying for this litigation. Now, if it must be said, yes, I am absolutely biased. I am telling you my story from my perspective. And I know that means I'm going to probably put little spins on things that I might remember differently than how it happened, especially because I have PTSD. I often have to refer back to legal submissions and decisions as I'm doing this podcast to make sure that everything I tell you is accurate. But that's exactly why I created my website, because I do want people to look at the documents themselves if they're questioning anything that I'm telling you. That's the reason I put that site together, citing all of the public documents and legal decisions. Because ultimately, I do believe that whistleblower retaliation is a matter of public interest. And it's happening right before your eyes and on the public dime. If I had never made my delegation to the board in 2016, would they still be coming after me the way that they are? Would they still be paying public dollars to try to achieve my silence? You don't have to agree with me that what I'm facing now is whistleblower retaliation. But if you don't, you really should be asking yourself, what is the goal of all of this? If I was defaming the Waterloo Regional Police Service, why would they not just lay a lawsuit against me in civil court? If I was going onto my social media platforms and making up lies about them, it seems like it would be a pretty easy case. But here we are, 7 years and over $635,000 of public funds later, and they're not giving up. So going back to the point I made in episode 1, I believe this entire ordeal is to further solidify the culture of fear in policing. Can you imagine anyone sitting by and watching what's happening to me and then choosing to do the same thing and speaking up about an abuse of power they witness inside a police service? I have faced a coordinated effort for the past 7 years to keep whistleblowers silent. And no one is going to convince me any differently. So many other countries around the world have made whistleblower protection a priority, but Canada has not. And my goal with this podcast is to educate the general public so that we can force our lawmakers to create robust, far-reaching laws that will protect anyone that comes forward with a matter they believe is in the public interest. It's those people of high integrity that we should be promoting. But in Canada, our leaders tend to silence those people in order to control the narrative, and this has to change. So as I've said, I'm telling you my story from my perspective, but I've put all the documents on my website for you to go and see for yourself. The facts speak for themselves. It's one thing for facts to not have been proven in court, but what if the facts are not ever able to be proven in court? That is the whistleblower's reality. So let's go back to 2018 when I filed my simple statement of claim on May 9th of 2018. Now, in the statement of claim, I cited the clause I believed had been violated by Chief Brian Larkin and the police service. And I won't read it all to you, but it basically says that the contents and mere existence of the resignation agreement were not to be disclosed. And as I've said, I believed that Chief Brian Larkin's disclosure in his sworn affidavit in defense of the class action was disclosing the terms of my resignation agreement. And yes, I could have just let it go. I could have chosen not to do anything about it. But it really sent a message to me that they were just going to completely disregard the legal contract that we entered into. I didn't walk away from 24 years as a police constable for nothing. I left the profession because of the promises that were made to me in that resignation agreement. And I wasn't going to sit back and just watch them violate it like it didn't even exist. So, as I've said, 51 days later, the police service filed their case against me at the Human Rights Tribunal of Ontario. And basically, it seemed right off the bat that they were claiming that I was making complaints against them. Their 31-page application had about 400 pages of evidence attached, and it was basically alleging that everything I said publicly from the date of my resignation somehow violated my resignation agreement. The police service was asking the tribunal to order me to pay them significant damages to remedy the ongoing damage to their reputation in the context of intentional and repeated violations of the most fundamental nature. They really did make me sound like quite a villain. But right away, within the required time frame, I did respond to their application, and I made a request to dismiss the application for several reasons. 9 days after that submission, I received a letter from the registrar telling me that he was going to schedule a full-day hearing for the merits of the police services case. I wrote him back right away and I said, "Excuse me, sir, are you also going to be hearing my request to dismiss?" And then he responded by saying I could raise that issue at the hearing of their case. The hearing was scheduled for February 22nd, 2019, which was only 9 days after the hearing of the motion in my civil claim. So this was a big predicament for me. What was I going to do? Because if I waited and then on February 13th we had a hearing in my civil claim, I probably wouldn't even have that decision back before February 22nd. I thought, what if I attend this hearing for their case and then find out a week or two later that my civil lawsuit is dismissed? Then they will have effectively completely turned the tables on me so that I'm now defending myself against their claim when I don't even have a claim myself. I didn't feel as if I was really given an option. I knew that I had to file a case at the Human Rights Tribunal as well, so I would at least be heard at the same time, which is what I did. As I've said before, I didn't believe that the Human Rights Tribunal had any jurisdiction over claims of a breach of my resignation agreement. It was an agreement that settled several ongoing processes, not simply a human rights complaint. And the crux of my civil lawsuit wasn't just that they had violated the agreement, it was that they were public officers who were acting as if the agreement didn't even exist. And I knew that the Human Rights Tribunal does not have claims over anything other than the breach itself. But on July 30th, 2018, I filed my own contravention of settlement application at the Human Rights Tribunal, hoping to be heard at the same time as the police service. Well, on the exact day that the police service's response to my application was due, I received a letter from the registrar of the HRTO, which contained a notice of intent to dismiss filed by the tribunal itself. The registrar was alleging that I had filed my application too late and I should not be allowed to proceed with it. The tribunal does have rules that an application has to be filed within 6 months of an alleged contravention of settlement, and the tribunal registrar was alleging that I filed it too late. I found it very odd that the police service had not even prepared their response to my application by the day that it was due, and the registrar himself was filing to dismiss my case. Now remember, at the time, I didn't know that the registrar was the former general manager and chief instructor of the Ontario Police College, but I still didn't understand at the time why it seemed like he was doing the job of the police service. It still seemed like the tribunal was never going to hear my request to dismiss the police service's case, but now there was a request to dismiss my case. And this was the start of me beginning to feel marginalized in the entire tribunal process. As I said, this letter was sent to me on August 10th, 2018. What I never expected was a knock on the door on August 11th of 2018. So remember, I filed my claim on July 30th, and this happened after. But a Purolator driver handed me a huge packet of papers, and then I thought, oh, what's this? Because that's basically how I was served with the police services application at the end of June. But I opened it up, and I was very surprised to see a WSIB letterhead. And it was a letter informing me of my employer's decision to appeal my claim. Now remember, I said that when I was resigning, the WSIB was going to continue to provide me medical care. They weren't going to be paying my salary. But I knew this, and I knew that I needed that medical care in order to recover from my PTSD and be a productive mother and member of society. But here it was in black and white, a letter informing you of your employer's decision to appeal your claim in this matter. And I believed this was, yet again, a blatant violation of my resignation agreement, as if the document didn't even exist. And not only that, I do believe that it was intended to cause me harm. And I think that's pretty obvious because they wanted to remove the only medical care I was receiving. It could be said that the medical care I was receiving was keeping me alive, because it's very well known that first responders living with PTSD are at risk of suicide. Because I was now fighting a two-front war, I had to amend both my civil claim and my HRTO application to reflect this second allegation of breach of contract. I'm giving you these details now because they're very relevant even today in 2023 when it comes to the HRTO proceeding. So as I've told you that throughout 2018 and 2019, I provided the tribunal with evidence that I believed contributed to my belief that the police service filed their case against me purely out of retaliation because I filed my civil claim against them. Well, in September of 2019, when the HRTO released that interim decision, the adjudicator had decided that she would only proceed on 4 preliminary matters, and none of them were my request to dismiss the police service's case. She was going to proceed with my request to amend my claim to add the second alleged breach. And she was also going to proceed with the registrar's notice of intent to dismiss my case. So if I haven't already lost you and you are following along, I now had 2 alleged breaches of the resignation agreement. But the date that I filed my initial claim falls right between the 2 alleged breaches. I didn't know about the WSIB appeal when I filed my case on July 30th. I found out about it on August 11th. The tribunal rules state that if you're claiming a contravention of settlement, you have to do so within 6 months of the alleged contravention of settlement. But if there's a series of contraventions, it has to be 6 months from the last contravention. So in my case, I was alleging that the last contravention happened on August 11th, 2018, because that's when I was made aware of the WSIB appeal. But I had actually filed my case ahead of that. So it seemed to me that the registrar's notice of intent to dismiss my case was now a moot point. There was now a series of incidents, and my application was timely. But don't forget, this 2019 interim decision was written after I had accused the adjudicator of favoring the police service and the registrar of being in a conflict of interest. And after that September 2019 interim decision, I didn't hear anything from the tribunal for 30 months, 2.5 years. And all the while, as you've heard, my civil claim progressed. I won at the Court of Appeal. The original motion was revisited and decided again by Justice Bealby, again dismissing my lawsuit, this time specifically for lack of jurisdiction. So we returned to the Court of Appeal for Ontario for the second time, of all dates on February 14th, 2022. So I got to spend Valentine's Day 2022 with Justices Roberts and Sawson and the Chief Justice of Ontario at the time, Justice Strathy. Now, the Court of Appeal for Ontario is much more efficient than the Superior Court in that they give you an allocation of time to speak and are pretty strict about holding you to that time. what I find extremely frustrating as a self-represented litigant is that the justices will repeatedly interrupt and ask questions and seek clarification on issues, but this eats into the time that you're allocated to speak. I tried to address all of the key issues of my appeal in the time that I was allocated, but it was drastically cut short by question and answer periods. So try to understand this from the perspective of a self-represented litigant. I had already taken weeks and months to prepare my written appeal material, which included a factum, an appeal book, and exhibit book. But what it really comes down to is what you say during oral arguments. If you don't address every single argument in your factum in your oral arguments, it's like it didn't happen. So try to imagine the stress on a self-represented litigant speaking before 3 very senior judges at the Court of Appeal for Ontario. I've met some lawyers who go their entire career without ever presenting arguments in front of the Court of Appeal, and here I was for the second time. For the most part, I think I stayed on track, but some of their questions really threw me off, like when Justice Roberts suggested that once I had amended my claim to include the tort of misfeasance in public office, I had somehow reopened the issue of jurisdiction, allowing them to go back and revisit the lower court motion. I thought if this was the case, then why did I not find several other cases where this had occurred, where an unsuccessful litigant after an appeal was able to go back and get a second kick at the can? I was also now alleging that there may be an apprehension of bias on behalf of Justice Bealby. I had done this because of the publication ban that was issued in my case. The publication ban explicitly cited that one of the litigants had shared the information on their social media. So I was reasonably suspicious that Justice Bealby may have read that CBC article and pointed the finger at me for the Zoom bombing. Had he done that, he would be biased to rule against me as I was the troublemaker that disrupted his courtroom. Now, I didn't do this to insult the institution of our justice system. I did it because I knew the definition of an apprehension of bias. The definition states that a reasonable apprehension of bias happens when an informed person viewing the circumstances realistically and practically concludes that a decision maker may not be impartial or fair. And I did see myself as a reasonable, informed person. And when I viewed the circumstances, I did believe that there was reasonable apprehension of bias, that had Justice Bealby read that CBC article, he may be inclined to rule against me, which is what happened. I also knew that if I was going to proceed with this issue beyond the Ontario Court of Appeal, I had to raise the issue now or I wouldn't be able to raise it again. So if you're curious to read all of the legal arguments I presented before the Court of Appeal for Ontario the second time, you can read my entire factum on my website, policeversuswhistleblower.ca. So around the time that we were reattending the Court of Appeal, the Human Rights Tribunal wanted to reopen the matter. Don't forget, this was after a 2-year hiatus, and I had requested that they wait at least until after the Court of Appeal decision had been issued. It still didn't make sense to me that we had 2 different proceedings about the same thing happening in 2 different venues at the same time. Despite the police service objecting to putting it off, the tribunal did decide to wait until after the Court of Appeal had issued their decision in my case. And that decision came on March 10th, 2022. And this time, I had lost the appeal. Or had I? Justice Bealby's ruling was to dismiss my lawsuit without leave to amend. At paragraph 42 of this decision, the Court of Appeal states that they dismiss my appeal, but in the particular circumstances of the case, they vary the order of the Superior Court by staying my action until such a time as my remedies under the collective agreement and at the tribunal have been exhausted. So this left me confused. Had I won the appeal or had I lost? My opinion was that if I had lost the appeal, then Justice Bealby's ruling would stand today and my lawsuit would be dismissed. But that's not what they did. They varied Justice Bealby's order and allowed my lawsuit to be stayed until I've exhausted remedies in other places. I had already been trying along the way to access remedies through the collective agreement, and I had been denied every time. I had also filed a case already at the tribunal, but it wasn't addressing my entire claim because, as I've said, the tribunal doesn't have jurisdiction over claims for misfeasance in public office. So I felt like I was just continuously being put on this merry-go-round to go from venue to venue to venue, trying to seek access to justice. Now, you have to understand, I'm not just a sore loser. I have lost in court before, but I understood the ruling and it made sense to me. But in the case of this duplicate motion, none of it made sense. The Court of Appeal couldn't even point me to one case where this had been attempted and succeeded. All I wanted was proof to know that what was happening to me was fair, and I didn't seem to have any of that. I was really starting to feel like I was being punished for even trying to hold the police service accountable. It says at paragraph 44 of their decision that although I submitted a supplementary notice of appeal indicating that I wanted to appeal the $15,000 cost award, I didn't make any arguments in support of that position, so that cost award was upheld. I was able to successfully argue that we had divided success on the appeal and there would be no cost award for the appeal. And this essentially put me in the same position I was in February of 2019, 3 years prior. Except it was like my first appearance at the Court of Appeal had never happened. Had this all just been a bad dream? When I told you about my allegations against the registrar at the tribunal, I told you about how Chief Brian Larkin at the time had been the president of the Ontario Association Chiefs of Police. Well, what I haven't mentioned is that throughout this entire ordeal, he was elected to be the president of the Canadian Association Chiefs of Police. So Chief Brian Larkin was essentially the top police chief in Canada throughout this period of time. Since none of my allegations against him had been proven in court, it was as if that all of this really didn't matter, that I didn't matter. 1 month after the release of the Court of Appeal decision, Chief Brian Larkin announced his retirement. But he wouldn't be retiring, he would be taking a deputy commissioner's position at the RCMP. So he was off to bigger and better things, and the region of Waterloo continued to fund his legal defense. And people were really starting to look at me and ask, like, when are you going to give all of this up? So it was really starting to look like I had given up 24 years of my profession as a police constable for nothing. I didn't have the protections I thought I had in the resignation agreement, and I wasn't even able to enforce it against them. According to the Court of Appeal, I had to exhaust my remedies at the Human Rights Tribunal and through my collective agreement. So I once again made a request for a grievance to my association, and that request was denied. I made it clear to the tribunal that if I was going to exhaust my remedies at the tribunal, I had to bring a claim before the tribunal that was identical to my claim in court, for me to determine exactly what remedies were available to me at the tribunal. After a series of teleconference calls, it was determined that we would proceed with a preliminary hearing in September of 2022. This is 3 years after the interim decision of 2019. Now, let me tell you about another extremely annoying aspect of the tribunal. In 2019, if you recall, I was ordered to make all of my submissions because up until then, I hadn't been submitting my documents because I felt like I wasn't being afforded procedural fairness. Well, after the weeks and months it took for me to compile my 6 volumes of submissions, here we were 3 years later, and the tribunal was telling us to make our submissions again, simply because the adjudicator didn't want to have to go back through all the paperwork on file in the case. It just begs the question, why do they have such strict timelines for submitting documents when, in the end, they're going to ask you to make it easy for them anyways? And we were now provided a new adjudicator, but that didn't really change the course of this case. I had informed the new adjudicator that I had previously made several requests to dismiss the police service's case, but that wasn't an item identified by the previous adjudicator to be decided at this preliminary hearing. It didn't seem to matter because the new adjudicator decided to proceed only with those 4 issues identified by the previous adjudicator. It just seemed that my request to dismiss the police service's case was never going to be heard by the tribunal. Now, if you're one of my keen listeners and you're actually going to my website and looking up these legal decisions, you're going to see a few things jump out that I haven't mentioned. And it's not because I'm ashamed of anything or I'm trying to hide anything. I'm just trying to address what I feel is important. But you will see that it comes up from time to time that I recorded a teleconference call that occurred between the parties. Now, if you live with PTSD, you'll understand the issues with short-term memory. I had made several requests for an in-person hearing in these matters because an in-person hearing would allow me to bring friends and supporters with me, particularly people that could take notes on my behalf or remind me about things that would have been said, because it's really hard for me to keep track of what is said around me while I'm still paying attention to what's going on. It is a short-term memory issue. But when it comes to telephone calls, I tend to record most of them to make sure that there isn't something important that gets said that I miss. Now, in the case of a tribunal teleconference call, there are no rules that say that it cannot be recorded. It's clear in the tribunal rules that if you want to record a hearing, the person requesting the recording has to pay for a court reporter themselves, and also they have to pay that reporter to produce transcripts to give to the other side. So it is a cost-prohibitive rule. What I find a little bit disturbing is that even the Court of Appeal for Ontario has said, why doesn't the tribunal just record everything? It's so simple now. And especially because they conduct hearings by Zoom. The recording is automatically produced for them. I could understand the cost to have a transcript produced, but it doesn't seem to make sense to me in today's climate of access to justice and procedural fairness for litigants that we wouldn't just automatically record every hearing like we do in court. If you hear me say that access to justice in Canada is impeded by the administrative justice system, this is why. Because we have an open court principle that allows for transparency and accountability. But in the tribunal system, it's all very secretive. I remember reading somewhere that this was to keep the hearing somewhat informal, and it was written in a way that is somehow beneficial to the litigants. But I have not met one litigant, especially a self-represented litigant, that would not have appreciated the hearing being recorded. As I've said many times, I do believe that self-represented litigants are marginalized throughout this process. The reason my recording was even an issue in this case was because at that teleconference call, what I captured on the recording was the adjudicator saying that she didn't even know she was bound by a code of conduct. And when I asked her, well, to whom can I complain about your lack of compliance with the code of conduct, she said she couldn't tell me that. It really was disturbing for me to hear this from the mouth of the adjudicator overseeing our case, but it also contributed to the overall professionalism of the Human Rights Tribunal of Ontario as a whole. I knew that if this was a recorded hearing occurring in court, she never would have said these things. And that's the crux of the problem right there. What else is occurring at these teleconference calls that's not being recorded that really should? There doesn't seem to be any quality control over something so important for somebody who brings their case to the Human Rights Tribunal of Ontario. So, in accordance with that last ruling by the Court of Appeal for Ontario, I attempted to gain remedy through my association and was denied yet again. I now only had remedies available to me at the Human Rights Tribunal of Ontario before returning to potentially lift the stay on my lawsuit in civil court. I agree with you 100% that this is ridiculous. But keep in mind, this was the only course of action I could take in my attempts to try to hold the police service accountable. The only reason I had given up my career was for the protections I thought I was afforded in my resignation agreement. Obviously, at this point, I knew that that document wasn't worth the paper it was written on, but I still didn't know to what lengths the police service would go to continue to aggravate me and grind me down until I had nothing left. So I've brought you to about September of 2022. At this point, the police service had spent about $550,000 on their legal fees, and the story still isn't over. In the next episode, after 4 years, we'll finally have a hearing at the Human Rights Tribunal of Ontario, and I'll finally be trying to hold my association to task. Stay tuned.